afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our speaker. So please, if you have a question about anything we're talking about today, please put that in the comment section below the video, and we'll be sure to address it. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon so you don't miss an episode. Today, we have Lucas Foust with us to talk about institutional plaintiffs. Now, last week, I mentioned to all of you that I don't know what the heck that is, and we had been trying to sort of figure it out amongst the speakers. What is it? What is it? And based on the blurb that kind of went out to advertise this week's topic, I think I might have a little bit of experience with them. So I'm excited to learn more about what we need to know to protect our clients with these sorts of folks. Let's get started. Lucas, do you have a PowerPoint or something to share with us? Let's talk about institutional plaintiffs.
I do. Jenna, thank you for having me here today. We're going to talk about institutional plaintiffs, the who, what, where, when, and why, and I'm going to share my screen with you. See if we can pull this off. All right. So hopefully you all can see that. Is that good, Jenna?
I can see it.
All right. Today we're going to talk about institutional plaintiffs, the who, what, where, when, and why. And I'm going to lead off with a story, a brief story about just how fast people can spend money. And this is part of the motivation. It's a story early in my career. I'd been at about 6 or 7 years. And my law partner at the time, we had settled a case, a very solid settlement, and provided this middle-aged woman about $105,000, which in my house is an awful lot of money for most people's houses. But what happened is so we thought we were being really smart. We gave her the names of 3 possible investment advisors, and one of the things I want to get across with this institutional plaintiff. What I'm not suggesting you do is tell your clients what to do with their money. You need to protect your clients from expending their money so the money lasts as long as they're alive. These are involved. You get involved with these with very significant cases. You don't need one with a $25,000 case unless it's a child. But having an institutional plaintiff in place early is critical. Now, I mentioned this, my client was a Native American woman from Hardin, Montana. She was injured in a slip and fall situation at a shopping convenience store in Billings. And again, we got about $105,000. I mentioned that she's Native American for this reason. We all have different values that we value on money. I'm not telling you what to tell your client what to do with their money. Don't ever do that. We all have different values and value systems. So for instance, you might have family members that are hard up for cash. That's not what this is about. It's about protecting your client, putting something in place that's going to protect them. So we get the check for $105,000. We thought we did our job. We gave her 3 names of folks she could call for financial advice. 2.5 hours later, we get a call from a car dealership. Is this check good? Our client just spent $105,000 in 2.5 hours. It's our current land speed record here in Montana. I haven't heard anybody top this yet, but she bought a Hummer and a Ford F-150, and she's heading back home. That's between here and her home. She spent the money on the way home. So we're not telling folks how to spend money. That's great, whatever. I mean, $100,000 is a significant amount of money, but it's not totally life-changing. The types of cases we're talking about here are folks who desperately need the money, and they don't have sufficient faculties to make the decisions that they need in the future to manage those funds. So the who, what, where, when, why of institutional plaintiffs is what we're going to talk about today. Institutional plaintiff, who needs an institutional plaintiff? Literally all of our clients do. You're going to see some statistics that are pretty surprising here about how quickly folks rip through their money. And, I tend to think of funds this way. Money sends your life in a direction faster than it's already headed. So if your life's heading in a good direction, money will help propel it in a better direction. If your life's going downhill, it's going to make it go down faster. And you see that in everyday life with people about the decisions that they make. We're going to cover what an institutional plaintiff is. Where do you find an institutional plaintiff? When should you start the process? And this is critical. This starts at the very beginning, and we'll talk more about that in a minute. Why do you need one and not even know it? There's a lot of reasons why you need one. It helps set your case up. Importantly, I'm going to talk about this some more. It changes your mindset of handling your case from the very, very beginning. And I'm going to talk a little bit about my journey and challenges in Montana with institutional plaintiffs and kind of what I've encountered. But we'll go ahead and move on to the next slide here. Hey, folks, this is what they think of your client. This is what they think your client does with their money when they get it. This is from Dumb and Dumber. The $105,000 is kind of right on par with this deal here.
We'll take it.
Hold on. I'm going to start that again because I don't think I'm sharing my screen. I don't think I'm sharing my sound, am I?
Oh, yeah, share your sound. I was wondering if it was
No, it's
sound and
not.
I was missing
We'll
it.
do
Okay.
this. I'm going to stop the share. Just give us 1 second. You got to have the audio. Come on, man, please. Hold on here.
I know. I was like, wait, I don't remember this
So,
part being silent, but maybe it's
Just
silent. I don't
1
know.
second.
You know,
Here we go. I can get that.
Yeah.
I will fix it.
We had a client also buy a car one time. I remember afterwards, we were like, you're an adult. You get to do whatever you want with your car, or, you know, with your money, whatever. The next time we met her, car. And we were like, okay.
Of course. Well, why wouldn't you do that, right? It's going to keep coming.
Yeah.
This is from Dumb and Dumber. We're going to fire this up at the beginning. Here goes music to this too. So here we go.
We'll take it.
There you go. There you go.
Thank you, sir.
There you go. There you go. There you
That's what the jury thinks your client does on the way home from the house, actually, okay?
Yep.
Who needs an institutional plaintiff? Listen, we all do, okay? If you come into this kind of money and you're not unaccustomed to managing this kind of money, it becomes a situation where it is almost more trouble than it's good for. About 70% of people who win a lottery or get a big windfall actually end up broke in a few years, according to the National Endowment for Financial Education. Folks actually end up in worse financial situations when they have an unrestricted access to a large amount of money. They get themselves in, they borrow money they couldn't, they're accustomed to doing that. I basically try to teach my kids as they've been growing up not to borrow money and just how the problems with that. But if you've never learned otherwise, the banks will gladly lend you money because you have all these resources available. And next thing you know, it's all gone in a few years. You just get yourself in trouble. Who needs an institutional plaintiff? Literally every one of our clients, but especially children, anybody who's brain injured. And what I mean by that is you're making a claim for a traumatic brain injury. Now let's just stop and think about what that means. That means that you're explaining to your audience that this person cannot make good decisions. So, hey, y'all, I have a great idea. Why don't we just give them a whole bunch of money and see if they can act like Jim Carrey did in that last video we saw. It's just a really bad idea. The same thing's true with folks who are a little elderly. You know, that's one of the things we're encountering more and more often with clients, elderly folks who can easily be taken advantage of. And finally, well, anyone who's suffering from a diagnosed mental health problem. I'm going to talk about the case we had in Montana where we ended up getting, believe it or not, 14 separate institutional plaintiffs or conservators and guardians ad litem for 14 different women because they all suffered from mental health issues. And we really felt we needed to do that to protect their interests. You have to find a way. It's difficult to make an argument for someone who, for instance, is an amputee, that they necessarily need one, but you really need to have good, important discussions with those folks before they move on. You're not going to necessarily be able to get an institutional plaintiff for an amputee necessarily. necessarily. So this comes from the Edge 1. An institutional plaintiff is normally a financial institution, trust officer, or someone with a financial background. You simply petition the appropriate court. That's a lot more complicated than it just says. There's a lot to it. We'll talk about in a minute. To have this institutional plaintiff appointed to handle the property of the plaintiff. That's in Edge 1, page 160. If you all are new to the Edge, one of the things I do recommend that I found good, and this is over the process of years, is quite literally reading a couple of blogs every day. That's what I did, and that's what I came across this institutional plaintiff notion and started implementing in my practice, and it really has changed my practice for the better. What is an institutional plaintiff? Know your law. Every state has its own rules, and every state has its own process you have to go through. Be familiar with it. Understand the difference between a conservator and a guardian ad litem and a trustee. All those are very specific terms of art, and you need to understand those before you go out in the process of figuring out how to protect your client, protect their interests in the future here. Conservator, guardian ad litem, guardian, you got to know the difference. And again, every single state is different. So I'm going to talk about what I found in Montana when I went through this process. A lot of states are similar. A lot of states are a little bit different. One thing I would do is if you come into some roadblocks that are confusing, et cetera, someone who does estates will almost always be very well versed in this process because it's the type of thing that's set up on a regular basis for large estates. Where do you find an institutional plaintiff? Well, hey, start with your listserv. I track all the listservs for the Edge throughout the country. So I know the traffic, and I know some states are really good. Some states are lukewarm. Other states, you see them once every 6 months. But your listserv is going to help you out with this, especially locally, to figure out who they've worked with as an institutional plaintiff. And we'll talk a little bit about when you do it, how you implement that person, but you want to get them early on. Move on to Edge attorneys in other states. When I was in the process of setting up some conservators, et cetera, Russell Button was really good with his time. He's out of Dallas. He's out of the Dallas, Texas area. He and I talked about it, making certain that what I was doing complied with the law in Montana with what the objective was. I'm available also. Feel free to contact me if you want to discuss and spitball how you get your institutional plaintiff going and set up. You want to do this before you file suit, and I'll talk more about that in a minute. Go to a firm with an estate practice. That's helpful as well. If you run into roadblocks, these are things they use all the time. They're just a tool that helps you get your client where they need to be and take care of them. Find out who handles money for disabled folks in your community. And we have people who serve professionally as conservators for folks who maybe are disabled for mental health reasons or for brain injury type issues, at all sorts of other reasons. But they help manage. There's going to be someone in your community who does this at the courthouse. This takes a lot of work. I'm going to talk to you more about that, but this isn't easy. If someone in your area has done it previously, there's no reason to reinvent the wheel, but it's definitely not easy. When you get an institutional plaintiff, I'm going to show a little video here from the Titanic. Folks, we all can have the greatest case in the world that comes in our doorstep. Just like the Titanic, it's a beautiful thing. It's just gorgeous. You got everything all lined up. But if you don't take the time to do the work beforehand and get ready for unforeseen consequences, you're going to do something stupid like not have enough life rafts on the ship, or you're not going to have enough, or you're going to run the ship at full speed and not be able to handle it. But we'll talk a little bit about this. You want to start at the very, very beginning. From the very first meeting is when you start. So if you all remember the Titanic, here's a little. Folks, we all know how that story ended, and they were not prepared for what was this is the opposite, okay? You want to ask yourself, is my case that I'm sending out there the Titanic, or is it a destroyer? If you haven't seen this movie yet, this is a great movie. This is Greyhound with Tom Hanks. This is the torpedo scene. And understand this, the Titanic is, it's like your cases. Sometimes they're great, but if you haven't done the prep work on the beginning of it before you file the lawsuit, it's going to catch up with you almost invariably. Here's the destroyer, the torpedo scene from Greyhound.
Contact.
Sir, with torpedo starboard beam bearing 187, range 1500, sir.
Left full rudder. Left full rudder.
Second torpedo to starboard beam! Bearing 120, raise 1000!
Right hard rudder, hard over. Right hard rudder, hard over.
Delay that! Meet her!
Belay, meet her.
Aye, sir, holding course. Right hard over! Starboard, slow and start, port ahead, full!
Starboard slow, start, port ahead full.
All hands, brace for collision!
All right, just compare that with the Titanic hit a stationary object and couldn't handle it. I mean, listen, here's the deal. You want to get it early. Prepare your case before you file the lawsuit. Think destroyer, not Titanic. We have a checklist in our office. We're required to complete 23 different things before we file suit. There's a checklist. My wife is my paralegal. She is my supervisor. She makes sure I don't take too many cases on, but she importantly makes sure we've done every single one of these things before we file suit. Get your office staff involved in this because you got to do this. I'm going to go over the 22-step procedure we use, and it's not mine. This is what I got from the Keenan Law Firm. I've been fortunate enough to work 3 cases now with the Keenan firm, and every single time I get into a new one, I learn more. But I think the biggest thing I take away from my experience with the Keenan Law Firm is understanding absolutely how imperative it is that we have our cases prepared before we file suit. You got to be ahead of the game, or you're going to get your lunch eaten. Open up the discussion with your client, his or her family, early, right after your case selection, and make this a priority. We're going to move on. So just to give you all an idea of what we do in our office, there's a 23-step process we go through. We do memos for each and every one of these before we file the lawsuit, and most of these are done before we even take the case on. So we do a case selection criteria memo. I have one of those done on any significant case we have in our office. Do you do this on a $25,000, whiplash case or something along those lines? Not to minimize those claims, but you don't necessarily need to do this. But if you're looking at a substantial claim, you better do every single one of these things before you file suit, because it's a difference between being the Titanic or a destroyer. Next, we do a fact memo. We fully understand that. I pull all the jury charges, all the jury instructions. We do a verdicts and settlement notebook that goes along with it. Number 5 is critical. You better know how much your case is going to cost you, your household. I'm a solo practitioner, so I better know what the hell 5 is so I can have those resources available, or I'm going to end up mortgaging my house, which is nowhere you want to be as a plaintiff's lawyer. Codes memo, you should know the codes in your case. Rules and checklist memo, prepare your rules right away, and you do your checklist also. Obtain all medical records, you do your PowerPoint timelines. Liability and causation experts are contacted and hired well before you file suit. You better know who's going to be good, who's not going to be good. And definitely the number 13 is critical. You better have at least 2 or 3 focus groups under your belt before you file suit. You better know what Bubba wants. The only way you're going to get there is if the only way you're going to get Bubba what he wants is if you know what the hell he wants. So you better have a pretty good handle on that before you file suit. We do a damages memo, a client biography. Man, I just kind of blew over these before. That's a critical element in what we complete now. Your family tree, your endgame memo, your statistic. My opening's already drafted before I file the lawsuit. I've typically done 1 or 2 of those before we even file suit. I've run it by a focus group a couple of times. We tape before and after witnesses, especially in TBI cases. Again, your liability, reconstruction, standard of care, life care planners, those folks are all hired. This is before you file the lawsuit. You better have all this ready to go before you get serious about investing your time, money, and effort in this particular case. So that's what we do. Included in this list now is getting an institutional plaintiff when it's necessary. We're going to talk a little bit more about that. When you talk about an institutional plaintiff, parents of a child, in this state, every single case involving a minor must have a conservator appointed or a guardian ad litem. I do both. The conservator, who's in charge of managing the resources, and a guardian ad litem who helps basically check your work on a significant case. I'll talk about the GAL in just a minute here. Any clients with a traumatic brain injury, clients with mental health problems, and again, elderly clients, all those folks desperately need them. I believe you're committing, come on, man, you're probably committing malpractice by not getting folks, those types of folks, those categories, GALs and conservators as necessary. Parents of a child, the first meeting is a good time to discuss with the parents of a child. Listen, you do not want mom or dad serving as conservator or guardian. It's terrible on a lot of levels. You want somebody who is not involved, and especially if your kid's injuries, your young person's injuries are life altering and lifelong. You just do not want to get mom and dad involved. It's not fair to mom and dad. Let them be a damn mom and dad. Don't put this on them. Mr. Keenan explains in the Edge 1 that once you describe the nature of the institutional plaintiff, the parents and or the client, they typically understand the only aspect that will be handled by the institutional plaintiff is, in fact, investments and disbursements. The parents remain guardians, in other words, dictating the educational, religious, medical, and recreational choices regarding their child. So I mentioned institutional plaintiffs specifically, and it varies from location to location. If you can locate a trust who's willing to serve as the plaintiff in the lawsuit, that is the best. And I'll talk about that a little bit more in a second here. Mr. Keenan in the Edge mentions that I don't have these kind of contacts, but he knew Hammer and Hank Aaron, and he's used Hank Aaron as his guardian ad litem previously, which is great. I mean, that's Hank Aaron and on behalf of Joe Smith or John Doe, and it's great. That's a great caption. It's a lot of fun. It's when an institutional plaintiff gets that point across. Okay, so when you talk to the parents of a child, it's not an easy conversation. Tell them, mom and dad, I want you all to be mom and dad. You do not need to be managing this kid's money. It needs to be the money stuff. Take care of that stuff and set it aside. You don't have to do it right away. Filing a lawsuit, especially in this state, you have until the child turns 21 years old. You don't want people wasting the money. If the parents are divorced or divorcing, you better get somebody way away from the family to manage this money, because it's just one more thing for these folks to fight over. If you all have done family law before, you know that there's hell hath no fury like someone going through a divorce with kids. I mean, it's just craziness. So you'd be crazy to appoint one parent over the other. Even if they say it's okay, that changes really fast. Mandatory. I make it mandatory for any of these types of cases that it's not going to be a parent. If you lose the client, so be it. You don't want them as a client. If they're not willing to get that much and understand that early on, good luck trying to convince them to either resolve the case or hold out for more money. Because if you cannot get a potential client to agree to have a neutral third party manage the money, you're never going to get them to be a good client. They're just going to be a nightmare for you. Clients with traumatic brain injury. All right. Married or single matters. And here's what I mean by that. If your client is married or has a significant other they're about to be married to, it does make a difference, because that person can help you evaluate the person's brain injury. That's really helpful, but it also helps if they're able to manage if you have someone in the household who already manages the checkbook, or maybe can manage the checkbook instead of your client, you're going to want to let the court know that, because it limits the scale and scope of the appointment. You want to move quickly on these, and you absolutely positively, you want to have the conservator and guardian ad litem in place before you file the lawsuit for a lot of reasons. Number one, it just gets this over with, and it gets that distraction done. So you don't have defense counsel chirping on you about, well, who's this new person that's showing up? Who's this new entity that's showing up? It's all figured out and it's all sorted out before you even file the lawsuit. And you can list the conservator in this state, you can, as a party to the lawsuit. If the family, in other words, the family finances function, limit the appointment. So if your family's able to pay their bills, take care of their daily day-to-day stuff, you can limit the appointment of the conservator very specifically. In these two brain injury cases we've limited the conservator so much that the conservator's only job is to make certain that any resources that go to the plaintiff go into the trust that we've established in a different state. I'll talk about that in a minute later here. Clients with mental health issues, that's another category of people that is often overlooked. If you're representing someone who has mental health problems that in any way make them compromised or create problems for them, it's going to cause problems for you as their attorney if you don't address those and deal with those issues up front. If you have a diagnosis, that's very helpful. It's got to be in their best interest, and you need to explain in your petition why it's helpful or why it's necessary, the appointment of this conservator or guardian ad litem. Elderly clients, we're encountering this more and more as boomers get older and they hit this category of age. You get a larger number of people you're working with who are in their 70s, 80s, and 90s. 70s doesn't seem old anymore to me, but 80s and 90s who they're going to need some help making certain that their funds are taken care of and they're taken care of for the rest of their life. Adult children, it's one less thing for the adult kids to fight over. If you set this up early on and have good discussions from the very get-go of your case about the involvement of a guardian ad litem or a conservator. Also keeps jurors from looking at your client's kids. Are the kids really the ones pursuing this case so they get the money in the end? That's the question. Now, why get an institutional plaintiff? It's the right thing to do. You need to look into this. And I mentioned this to Jenna before we started this today. Let's just think about this for 2 seconds, if you would. Just kind of take a pause, maybe a step back. You're going to tell an audience that your client has been so injured that he or she cannot make good decisions. Now, let's think about this for a second. I got a great idea to really screw their life up. Why don't we just give them a whole ton of money and then see what they do with it? If you haven't taken care of this institutional plaintiff, you're crazy. It's your first witness in your case as well. Banks, professional conservators, they play the long game here. So your conservators who are in this for a long time, banks are good about this. They'll have a trust department sometimes that you can go to. It varies from state to state. We don't have one anywhere in Montana. I looked everywhere, was unable to find them. It takes you, your case, and your client off code. This is your first witness, folks. This is the first person that says, we're serious about this. I'm not some damn game show host who's lying to you. I am way off code, and this is a serious claim that we have set up in a serious manner, and this individual needs ammunition to get through what is going to be one hell of a fight that is now their life. So that's what it does across the board. Change your mindset from the very beginning of the case, too. So my process to finding an institutional plaintiff in Montana, I didn't know where to start. People don't typically do this here. And in your jurisdiction or venue, you may be the first one. So you're going to have to cut some new ground in a lot of, my goodness, if you're in Wyoming, I almost guarantee you, in Wyoming and the Dakotas, there's no way this has been done yet. So you're going to have to plow some new ground. If you do it early, you have a lot less questioning eye than you do if you do it late after the lawsuit's been filed. So we have 2 traumatic brain injury cases. We have 2 cases involving therapeutic boarding school. The 2 traumatic brain injury cases, one individual, it's openly obvious that this individual has a brain injury. You can tell in about 10 seconds. The other individual we're representing out of this office, you simply can't tell unless you're with him for an hour and a half because his brain functions fine. It's firing, but it's firing so hard that after about an hour and a half, he is done literally for the day. He's over with, it's done. So even during the petition hearing, the judge is like, gosh, you look fine. Are you sure you want to do this? That's when you have all your prep work ahead of time. This guy really believes that the institutional plaintiff or the trust that we've set up is going to be super helpful for him. And being able to explain that and have that ahead of time before we petition was critical to making that an easier, smooth transition. So conservators and guardians ad litem were appointed, no questions asked after that hurdle was cleared. With the other individual, it's just openly, it was obvious that he's struggling with a brain injury, has trouble speaking, etc. So that was easy. The judge, like your jury, thinks that this individual is injured. It also helps. It really, really makes it abundantly clear that your client is injured. I mean, it's one of those things without even saying it, maybe subconsciously. If this is so serious, we appointed people to look after this person. Then you go a long way towards improving your case just from the get-go. The other case we had involved therapeutic boarding school cases. The primary foundation for our position primarily is these boarding schools here in Montana. We're taking in young women who had serious mental health issues. I mean, serious mental health issues when they showed up, and they had no business bringing them into an inpatient type situation with a complete lack of training that they had. One boarding school, we have 9 plaintiffs. Every single one of these young women, they struggle with mental health problems, mental health issues, and the same thing with the second school with the other 6 plaintiffs. So we had 15. One of them was in both of them. So we had 14 separate conservator petitions and guardian ad litem petitions we had to run through the court. One thing to mention. When I did the therapeutic boarding schools, there were some women we did not appoint either a conservator or a guardian, and there was a reason for that. We, in evaluating those situations, we determined it would actually be potentially problematic for them because the way they cope with the issues that they were dealing with, they needed a lot of control over their lives. So we skipped over appointing a conservator and guardian ad litem. I mean, one young woman we had who had mental health issues that really compartmentalize this stuff by having control. She found it necessary for crying out loud, she was 22 and she had a master's degree. So she kind of overcompensated, staying organized and staying on top of stuff. We were not going to appoint a conservator for her because we really felt, after visiting with the psychologist, that it would be counterproductive. So there are instances where you can have that in place. Someone has a mental health problem, but it doesn't fit. And that's, again, the exception to the rule. The other 12 of the other 14 women we did find it necessary to get conservators and guardians ad litem for both of them. Again, these were very different cases in the TBI. So we went to and I talked a little bit to Jenna about this. There is a huge difference between a neuropsychiatrist and a neuropsychologist. You better know the difference. There's a huge difference. If you do not know the difference, take some time to educate yourself about brain injury and who treats these folks and what they do. A neuropsychiatrist is a board-certified physician who is board-certified in psychiatry and neurology both. That is a huge difference from a non-physician who is a neuropsychologist. The neuropsychologist is just as testing. As our neuropsychiatrist, Reza Gomez, explained to me, a neuropsychologist is just like a Phillips screwdriver. A neuropsychiatrist is the entire toolbox. They look at everything to evaluate their brain situation, etc. They have a ton more credibility. You're going to always do better. The neuropsychologists are a dime a dozen. They're quite literally hacks, especially not all of them, but they can be absolute hacks. It's the type of it's like chiropractors. They're the type of business that you have flim-flam artists that matriculate their way over there. They don't even get through medical school. It just is not a very good screening process. Know your treating physician and communicate with him or her about the condition. Get an opinion on the need for assistance in decision-making, memory loss, and include that in your petition that you have. Know your law. It is any vulnerable client. I really believe in expanding this. Conservators can be limited in scope, especially if you have a functioning house and they don't have to take care of daily stuff. Just really make it limited in nature. Like I explained before, we made our conservatorship so limited, it was just making certain that any money in that lawsuit went directly into the trust. That's it. That's their only job. The GALs in this jurisdiction, They're there to help make legal decisions. And I'll talk about that in just a minute here. In Montana, these, and your state may very well be the same. Check out your case law. These appointments are never intended to be adversarial proceedings. They're just not. There are fights over who's going to be the guardian ad litem or conservator, usually conservator, over an elderly person, but they're not supposed to be. The appointment is in the best interest of the protected person. That's the key. The defense counsel in the underlying case has no standing to challenge the appointment in Montana. They just don't. It's also a good litmus test for what kind of jerk you're dealing with on the other side. If you're going against someone who I would call a defense lawyer, they're not going to say a damn word. They'd be, okay, I totally get it. That's a great idea. If you're going against someone who's a black hat, they're going to raise holy hell. The Taliban member will fight you to the death. So those are really the three levels of defense lawyers I deal with: the defense lawyers, black hats, and finally, importantly, the Taliban members who try to blow up the whole process. They do make ridiculous arguments. So again, this is your first witness at trial. Professional conservators, they know how to deal with disabled clients. They do that for a living. They know how to play the game. It's a long game. They know how to play the long game. Retired district court judges, that is a gold mine for guardians ad litem. I mean, come on. The most wise person you can find is an old district court judge. And that is, they're going to check on you. One of the things I didn't talk about previously is how important it is that when you're representing an individual who's compromised, you got to have somebody check your work. That's critical for a retired district court judge absolutely fits the bill for that. I use three of them now, three different district court judges for various purposes, and I kind of want to make sure they fit with the personality. One of the district court judges very religious, so if I know my client's religious, that's a perfect fit. The other guy's an old cowboy, and he will read in the riot act. And in this area, that sometimes goes an awful long way. So I'll tell him, this is the way it is, son. You got to figure this out. And then I do use a female district court judge as well, and that's critical depending upon the case. Sometimes it's very helpful to have it helps avoid the gender issues that might come up between myself and my client. Automatically your client may think that she gets them better. So you're going to want to gauge your client with the GALs you're looking at. You can also use an experienced a mediator who's experienced, and they could potentially be used as well. That's all that I have for the presentation here. Jenna, thanks for letting me talk about this subject. I'm available if anybody has any questions. And
yeah. Well, I have a bunch of questions. I've been taking notes because this is super fascinating. Young G and I have this conversation in our firm constantly about our adult clients, and whether it be somebody with, like, we just had a trial with a brain injured gal who was single and 70 years old. And we kept thinking, I don't know. I mean, but she was, fine, living on her own, doing these things, whatever. So we're like, does she need something? I don't know. Nothing in her medical records really supports that she needs something. We went back and forth and ultimately didn't do it. I mean, now I'm like, but I also really like the thought of that, getting somebody and having that person testify, and that really confirms that your client needs help, which is what that judge said in the hearing you talked about. Hey, you look fine. Are you sure you need this? That's what the jury is thinking too. And to have somebody, well, the judge thought it was important enough, or the lawyer did, or the client, whoever, the doctors did, to have somebody appointed to help you with your finances because you can't do it. That's huge.
So Jenna, one of the things I've encountered is this. It also gauges the way that you can expect your opposing counsel to act throughout your lawsuit. If they claim that this is a trick, it's because they're projecting the bullshit that they do themselves, right?
Yeah.
So if they're thinking, hey, this is just a trick, that's the type of person or opposing counsel you need to be aware of throughout the process, because they're going to be tricksters. If they think this is an acceptable process, then they're going to be an above the belt type of opposing counsel you're fighting throughout this that are going to raise legitimate issues. But if they're fighting you over this, get ready for all hell to break loose, because if they're going to fight you over something as important as this, they don't believe in your case, they don't believe in you, and they think that you absolutely are everything that is on code about a lawyer, because they are. That's what they are. I mean, that's how they see themselves. I really believe that folks project what they think about themselves upon you when this type of issue comes up. So that's what I've encountered, the cases I've had with this. So, yeah.
Yeah, that's great. So it can be used as a tool of exploration and kind of exploring the other side and seeing what you're up against in that battleship, right? What are you going to see from coming from the other side?
What do you got next? So, yeah, no, and start these early on. If you're taking a case on right now, think about this. Add this to your checklist of stuff you do before you get going. But yeah.
So, what about? Well, actually, why are they called institutional plaintiffs? Is it because they step in the shoes of the
Good
plaintiff?
question. So the two brain injury cases that I have are actually captioned Montana Fiduciary Management on behalf of Keith Doverspike and Keith Doverspike versus defendants A, B, and C.
Okay.
You actually put them in the caption. So in this state, they can pursue claims on your behalf as conservator. So once they're appointed, they then have the legal right to pursue claims on behalf of the protected person. Okay. They're actually in the damn lawsuit. They're a party.
Okay.
So try to get them out from testifying. That's an easy sell. Your Honor, come on. This is a plaintiff in the lawsuit, and they're not going to get to testify.
Totally.
It really. And the non-adversarial nature of this is also critical. So one thing I do recommend is this. Don't even think about trying to use this as something, as a trick. So don't use this as a way to say, I'd like the court to take judicial notice that this person has a brain injury. Do not do that.
Yeah. That
is not what this is, because then you will be falling into the same trap that they've created. So you got to prove up your case still. This is a tool to protect your client, not to make your case better first and foremost. So that's my thought.
And so they talk about then, well, first of all, I want to highlight that as well and underscore that, I suppose, that's important because so many defense lawyers, black hats, Taliban members, point to people who practice with the edge technique and philosophy and say we're doing tricks or we're manipulating the jury or we're golden ruling and all that stuff. So just folks, don't do the stuff that they're accusing you of doing. Do the right thing, which is to put this in place when your client needs it for their protection, not as a trick.
And that's the whole process. The edge is effective when it's used as a system for managing your case and not as a trick. If you think this is a trick, go do something else. I mean, this just run, don't walk away from the edge because we don't need you around. That's not what this is. It's a lot more work too. What I just laid out, I spent dozens of hours figuring out what the hell was going on first, really plowing new ground, and then implementing it took a lot more work than I ever thought it would. It just is what it is. So
totally. And that's something we constantly are talking about on the podcast as well, is that the edge is a lot of work. And so when I saw your slide and it said, this is a lot of work, I thought that's perfect because it's just what we always talk about is you're outworking the other side. You are proving up your case the correct way, which, I mean, if it was tricks, then you wouldn't have to spend a lot of time on it because it would just be tricks. It
would just be tricks. And I've been to, I was lucky enough to be in other colleges. I attended the Jerry Spence's Trial Lawyer College years ago. One of the things about it that's a very different process, and this is improving your casework and your work. That's what this is really about. So that's how those two colleges are different. But no, absolutely, Jenna.
Okay, what else do I have on here? Oh, okay. So say we're in the middle of a lawsuit, right? For folks who might be watching this episode, listening in now or come across it later, and we're like, oh gosh, I'm 6 months from trial. I think I might need something. Is there anything we can do?
Oh, absolutely. Well, think of this. You have now, what's the saying in Genesis? You have now eaten from the tree of knowledge. Now you know about this. You got the burden.
Yeah.
This is more important for your client than it is for your case. Okay. So if you have this, start the work on this right now. Even if you're 6 months or a year from trial, got a trial calendar, it's already worked out mostly. Go ahead and start the process. It is absolutely worth it. And there's another thing about it too. Once, maybe you'll get the person to testify, maybe you won't. That's great if you do. That's not the reason we do this. You're doing this to protect your client, and as a secondary issue, it improves your case. But it also changes your mindset. When you're thinking about this and you're playing the long game, well, you're looking at your life care plan differently. I mean, you're looking at, okay, my client Keith over here, he needs X, Y, and Z for 30 goddamn years. Who's going to pay for it? How's that going to go? And you start thinking about your case this way. One of the things that they're really working on now, one of the things that they're working on at the Edge, and I was at the Beach House working on part of this, they're really developing the closing damages section. And one of the things that's important to think of, your closing damages section needs to be about what your client can do and how the fact that the life care plan will help them continue to do it. It's not how goddamn miserable they are. Nobody cares about that. This propels your client forward. And the example that I used at the Beach House was your client needs ammunition to fight a really tough battle ahead of them. And that's what the life care plan is. You take that away from them, they will be pitiful. You know, they don't need your pity, they need ammunition. So that's how that life care plan comes to life, because you focus your closing on what they can still do. And they need this, goddamn it, jury, don't take that away from them too. Mm-hmm. That's the difference between a good closing and, hey, let's all feel sorry for this poor guy over here. That doesn't work that way. It's just it changes your practice. It changes your mindset. This is just another tool that's used to change that whole process. And what do you think about your case?
Yeah, absolutely. And that's what sets us apart. I still fall into the trap of getting a little bit, oh, poor clienty in my closings. And that's why we always talk about this Edge being a journey, is that you're getting better and better, and you go try cases and you see what doesn't work, and you go back to the colleges and you look at your notes again, and you keep trying and you keep doing it, because that's right. I mean, jurors want to compensate somebody for a purpose, not just give money to someone who's going to go, maybe overdose the next day or something like that.
Well, the way I would approach determining whether you need whether you need an institutional or a conservator or an institutional plaintiff is this: you need an institutional plaintiff until you're shown otherwise. That's the only way to approach this. You need an institutional. If someone's seriously injured, they need help managing that money unless they can show otherwise, period.
And this is somebody that you have to go to the court and have appointed, even if it's not someone you're going to name in the lawsuit. Is that correct?
Correct. So in this state, conservators fit a certain role. They typically manage money or resources. They also prosecute cases in this state. Guardians ad litem, they typically have a different role than a conservator does. And you can have a guardian ad litem and a guardian. Well, I mean, there's almost always a tool to fit in what you're going to need in your state statute, because what's happened to your poor client has happened to thousands of other people. And the laws in your state hopefully has been kept up with it and found a way to create a tool that you can use to protect your client.
Okay.
You got to go looking for it. You got to figure it out. Hell, take a state lawyer to lunch. Usually don't have the most riveting conversations with those folks, but it's okay. I mean, they'll maybe I take a free lunch from you, but pump them for information. Hey, what's the difference in this state between a conservator and a guardian ad litem? It's a steep learning curve, but it's worth doing.
Okay. And so an estate lawyer is one place we could look. Are there other places where we start this journey? It sounds like it took you quite a while to figure out your system and your process in Montana. Say we're somewhere else. Where do we,
call me. I don't care.
What do I do?
You can call me. I don't care. We'll just kind of work our way through it. Okay. Call myself, other Edge lawyers who have done this. This has been done a lot more in the southeastern United States than it has in the rest of the country. And that's where Mr. Keenan started this project. He does this in every case that they possibly can that he's ever had. They'll find a way to get an institutional plaintiff involved. But other lawyers, other Edge lawyers, I'm very serious when I say me too. You can contact me and we'll work our way through it. I'm happy to visit with you.
And for folks who are listening, we will put Lucas's contact information in the description under the video. So, if you have questions about this, feel free to reach out to him. He's, generously said on the record.
There we go. Give me a call. Yeah, absolutely.
Definitely. So what I'm assuming this person, if they're allowed to testify, talks about what the money's going to be used for.
Sure. Do
they talk about like the medical appointments that'll be used for, or just like I'm the person who's going to be helping out, or what exactly is that? Does that look like?
You have about 5 questions and get them off. It's a 3-minute witness.
Okay.
You get them. Hey, who are you? What do you do? Why are you here? What are you doing with the money? Hey, let me ask you this. What happens if you run off with the money? Well, hell, I go to prison.
Yeah.
I have a fiduciary duty to this person. I have a duty. If I screw it up, I'm out of here. I'm done. And that happened in my county. There was a woman who was in charge of this. She had a gambling problem. And so she ended up swiping money from disabled people. And there's nothing lower than that, right? Swiping money. So there's people who monitor this and ensure that your client's taken care of. But it's just a real quick in, out, witness, done. Get them off.
And when you say they go first, do they go before your liability witnesses? Are they just like your straight up number one before the 30B6, before everything?
Hey, everybody, who's this? That very, very, very first witness.
Okay.
Done.
All right. And
that helps. And also, they're going to see the jurors will also see the caption. If they're in the caption,
yeah,
then it makes sense. Oh, that makes sense. Okay. Now that's one last question. That's check that box off, move to the next witness. If the defense counsel is dumb enough to cross-examine them, let them.
Okay.
What are they going to say? I mean, come on. So
yeah, I don't even know what that might look like. I suppose they could
dream up stuff.
Well, do the plaintiff really need you? Do they? I don't know.
I'm not here to comment on that. I'm just saying who I am, right? That's easy enough. So
yeah. Okay. Do you have to have medical, or what do you need to prove it to a judge that this is necessary? And kind of with the understanding that it might be different state to state, but generally speaking.
Great question. Generally, again, this is a non-adversarial process. The standard is in Montana it needs to be in the best interest of the protected person. You outline what their deficiencies are. Usually with medical testimony, I'll get medical records, et cetera, and I'll include those in the petition. Those will, and I've never had a problem beyond that. I mean, and I think in that 12-month period, because of the 14 kids we had, I did 25 hearings in 1 year over this.
Oh, wow.
So it's 2 minutes. These are unopposed motions in this state, and they probably are in yours. The judges love these in this state because they go off how many cases they have. Mm-hmm. This is every bit as you get the same number of credits in this county for resolving this stupid 1 minute hearing as you do with a products liability case or even a death penalty case. I mean, so they're the same number. So judges love these. They like to check it off, move on. Here we go. And have your ducks in a row. That's the best thing I can recommend. Really, you need to be able to articulate the reason why you're doing it. Say, Your Honor, I'm very concerned because this person's been diagnosed with, boom, here you go. They've been diagnosed with a traumatic brain injury. This has impacted their cognitive ability. This person took a brief neuropsychological examination and scored in the first percentile. They're 2 full standard deviations below where they should be. This person suffers from cognitive difficulties. We're genuinely concerned that they're ripe for being taken advantage of. So one of my clients, this was interesting. So we set up the trust for him. We go to mediation a couple weeks in his case. But in the meantime, he got married. And I told him, I said, listen, man, this is the greatest prenuptial agreement ever made.
Yeah.
If this doesn't work out with your spouse, she ain't getting nothing. I mean, there's just no way because it's all tied up. I mean, his house, if we do well enough, he'll have a house that'll be owned by the trust. Mm-hmm, mm-hmm. And I've done that before. I've had trusts manage a home and lots of reasons. I mean, that just keeps a roof over their head. The trustee makes sure that all the taxes are paid. Mm-hmm. Something your brain injury client might not do.
Yep.
And it keeps a roof over their head. They're not on the corner of 19th and Main holding up a sign that says, we'll work for food or whatever. I mean, you don't see that. They're taking care of. They have a roof over their head. That's your objective. So
yeah. Okay.
And for what it's worth, if you set up a trust, well, the tax benefits are phenomenal. Because I mean, if he sells his house, he just puts the money back in the trust and avoids capital gains problems. I mean, it's in a lot of ways, he's the one that brought that up to me. And this is a guy who functions great for an hour, right?
Yeah. During his hour of lucidity, he's like, also, there's the tax benefit.
Yeah. By the way, look, I love this. It's a tax benefit. What?
Yeah.
Okay. That's interesting. So there are benefits you don't even think of.
Mm-hmm. Interesting. Okay. That's really great. So, oh God, I had a question. Now it's leaving my brain. I got to get it back. What is it? Oh, what's the difference between this person who is, I guess, part of the process, sort of, and like post-verdict, post-settlement, like a structured settlement person? Sure. Or,
So what we've done is this, this is a great question. So what we've done is we set up a trust. In these cases with the brain injury folks, we have a trust set up. The trust is set up, and there are no trusts in Montana. So there's no trust agency that we can work with. They're very disinclined to get involved in the lawsuit as a named party. So I appointed the conservator just to do one thing, to put all the money into the trust. From that point forward, after the case is resolved, that trustee then manages that trust and has a fiduciary duty to your client to ensure that the money doesn't run out. It's used for the purposes that it was received for. So for which it was received, and you're good to go. That's the trust. Yeah, I really recommend trusts. That's the best way to go. Annuities. I have a good friend of mine that sells annuities, but I would not do them again.
Yeah, and I think Papa Don has talked about it. And so, I mean, for folks like me who is like, well, what's the difference between a trust and then like when my client has their settlement, or so sometimes we will get during mediation, we will say, okay, we want a portion of this put into some sort of structured settlement or whatever, and then you name the company to receive the check or whatever. And that's not, I never asked the court permission to do that. I just kind of did it as a financial planning thing. But so kind of what's the difference there?
Well, first things first. Annuities are generally just crap. I mean, we can all see how inflation changes. We're all, it's up 70%. They don't make any sense for your client. You can get them in certain circumstances, and I've purchased them before. It's been years before I knew any better. Trusts are managed, the funds within the trust and the way that our trusts are set up, they're actually managed by a financial advisor who invests those funds. They don't just sit idle. They don't just gain a certain percentage of the interest of the bank.
Okay.
They're fluid. So the financial advisor oversees the investment package, and the trustee checks over that package. Okay. So there are fees associated with the financial manager. There are fees associated with the trustee. You will always do better with even paying those fees because they manage them in a smart way that makes sense. Most of these folks, the financial advisors you're working with, make more money the more money you make, not just selling you crap. So you'll have a financial advisor within the trust who will manage the resources and make certain that they're growing in an appropriate way to keep up with inflation and deal with those costs that are going to increase over time. So a lot of that, I was told there would be no math when I went into this business. So I'm not a very good source of that stuff, right?
Yeah.
So, but no, you hire someone who's damn smart, and believe me, my brother's a financial advisor in Spokane. I'll have to send you his way, okay? Yeah. So they make money on money in there that they have under management. Mm-hmm. They will jump out of their shoes if it's a $2 or $3 million deal. I mean, they're all over it because it's money to them all the time because they manage it. They increase the amount of that's generating, and it's just a different way to think about money. It just, your money goes out to get more money and bring it back. That's what your financial advisor in the trust does.
Okay, that makes sense. It's kind of like our role in a sense. We make more money the more money we make for our clients. So why would we not be trying to do the best possible for them? Absolutely.
So
okay. Yeah. And so my final question then is, how does the trustee get paid? Is it like us? Like when your income comes in, they keep a percentage, or is it a fee?
The trustee takes a percentage of the money that's in the trust. It's a very small percentage. The percentage is very small. It's not an insignificant amount of money. It's worth their while to manage the trust. Mm-hmm. They do a lot of things. The trustee will ensure, for instance, if you go purchase a house with a trust, mm-hmm. they'll make sure the house is, they do all sorts of stuff. Make sure that the taxes are paid, that it's kept up, stuff like that happens as well. So your client's not getting kicked out of they're responsible, the fiduciary duty to your client. Right. So they are compensated as a small percentage of the money that's under management, mm-hmm. and that's how they're paid.
Okay. And is that over time, or is it a lump sum in the beginning?
Oh, over time. Okay. Over time. So in other words, the trust will deplete itself over time. The amount of money they're paid goes down as well.
Okay. So that was my last question. It is not. I have one more. We have one more minute. Oh God, it's 1:00. So kind of along those lines, though, do you factor in those fees when you're looking at settlement amounts, or is it insignificant enough that it doesn't really matter?
I'm throwing that into the life care plan.
Oh, okay. All
yeah, I just have my life care planner say, hey, how much does the trust cost? I'm like, oh, shit, that's a great question. You're going to testify to that. So it gets in all over the place, right?
Yeah.
If you can't get them to testify if you can't get the conservator to testify, bring him in the back door. Okay. through your, hey, what's the trustee? Well, this is this much every year. Well, what's a trustee? There's going to be a trust set up. So, if that's the first time the folks have heard, at least they've heard about it.
Right.
And that checks that box off for your juror about, in our state, we have casinos, which are the bane of existence for about 1% of our population that can't control themselves. That is a common joke here. Hey, they're just going to go to a casino and drop all this. It's like near SeaTac Airport, you have those casinos.
Yeah.
God, I was there Thursday. It was packed. It looked like there was not an empty space in that parking lot. Thursday at 3:00 in the afternoon, I'm like, what is that? Is that normal?
Huge one in Tacoma, huge casino. I mean, they're out on the peninsula. I think there are 3 or 4 of them. They're everywhere. Yeah. I mean, they're everywhere.
So you have to, your clients getting this kind of money it can absolutely be a curse. So I think even if you're good with money, I mean, or whatever, most people have never seen the type of money that they're getting from a settlement or a verdict. They, even if you've been really good living on a $60,000 a year, whatever it may be, income, pension, whatever, and you're great at it, all of a sudden you get a lot of money. It's like, oh, wow, let's buy some cars. No, absolutely. Yeah, absolutely. So, that's, again, if anybody wants, my number's available, give me a call, and I'm happy to visit with you about the process I went through in more detail and how we can maybe help you set up something to help your client out and really change your mindset. That's the biggest thing that this has done for me. And this isn't a trick. You're going to be introduced to one hell of a lot of work, but you better get it done, because that's the only way to get your case done properly. So
awesome.
Yeah. Thanks for having me, Jenna.
Yeah, well, thank you so much, Lucas. And thank you to all of you who joined us live for this week's episode of Fridays with Keenan's Cutting Edge. If you liked the episode, please take the extra minute or second or whatever it is to click the thumbs up button to feed the YouTube algorithm, and don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we have a replay. I think the folks behind the scenes are going to choose what, former episode that is has the most likes and the most interaction, and they'll play that again next week. As I have mentioned in the past, some of our speakers have super busy schedules, as we all know, and so sometimes we just don't have the opportunity to go live. But the following week, I'm going to have Carrie Jones. We've had her before. We're having her back. She's going to talk about the Women's Summit. So I look forward to seeing you in 2 weeks. Have a wonderful weekend, and I'll see you next time.
Thanks, Jenna.